itself. And the standard setting organization says that, well, we will amalgamate all the technologies and we will implement it across the board in the world. So every handset manufacturer, any person who is manufacturing handsets or the chipsets, will need to comply with these standards, so that all the phones that are 5G compliant or 4G compliant or 3G compliant are able to, absorb all these standards, implement these standards. So then, if you are
Hmm.
using the patent for those respective standards, then the
Hmm.
question comes that how do you compensate the patent owners? Because the patent
Hmm.
owner has actually developed those technologies. So that's where the
Hmm.
rub comes in. That we will go into that a little bit more in detail. But just to understand the background of the SEPs, SEP really comes into play. So I
Yeah,
think
I think we lost. Hmm.
yeah,
Yes, yes. Okay,
yeah.
not
Now
an
we're
issue
back.
now.
Yeah.
Uh,
So I
uh
think
okay, so
SEP.
yes, ma'am, please go ahead.
Yeah. So because all the consumers across the board, they want the same kind of operations, they want the same kind of standards. So therefore, standard essential we cover a specific technology which forms a standard in the world.
Um, and how does this exactly work? So, what are the obligations of a patentee? Can anyone force the patentee to licensee?
So the background as to how this
Can anybody force
operates
the
is like
patentee
this.
to license?
Yeah. So let me just give you a
Yeah,
background.
but coming to what will be the obligations of? Hmm.
So I'll explain to you how this works. So now, if I am Ericsson or I am Qualcomm and I have the technology for this particular standards, let's say the 2G standard or the 3G standard, and my I have
Hmm.
got around 300 patents. Normally, these people will have about 200, 300, perhaps more. In fact, Ericsson has got thousands of patents, and similarly, Qualcomm also has
Hmm.
thousands of patents. So they have this
Hmm.
number of patents around the particular technology, and
Hmm.
they have agreed with the standard setting organizations that yes, I have the
Hmm.
patents and I'm making it part of the
Hmm.
standard willingly and voluntarily. And because I want everyone to
Hmm.
use it, I will license it on fair, reasonable, and non discriminatory terms, which is called FRAND, to everyone whoever will ask for it. So I will go around to the world
Hmm.
and I will tell them that look, I've got all these patents and I am ready and willing to
Hmm.
license it to you. And whoever
Hmm.
wants to take it on license is free to take it. So you can't
Hmm.
force him to take it, but he is under an obligation to give it to you on
Hmm.
license. He must give the technology on license to everyone, whoever is a chipset manufacturer or a handset manufacturer. He must give it to everyone. He cannot say that I have a patent and so I will not share my technology with everyone. The whole idea is to distribute and disseminate the technology across the board. The idea is not to hold up and to keep it to your breast. So even if you have 2,000
Hmm.
patents or 3,000 patents, or in that particular basket, you have some 10 or 15 patents or whatever is the number of patents, it is an obligation on your part to license it out to everyone. So the first approach is to license. In case the patentee does not license, so let's say you are Micromax, or let's say you are one of those chipset, you're a chipset manufacturer or a handset manufacturer, and you believe that you want to implement this particular technology in your phones, you want to bring out the new 5G phone, and perhaps Qualcomm or so and so has got a patent for certain of those patents, for certain of those technologies. Then you approach, normally they should be approaching you, and they would normally approach you to give you a license
Hmm.
for those technologies. And in case they refuse to give you a license on fair and reasonable terms, you are free to go to the court and say that look, these people are not giving me the license on reasonable terms, and I want them to give such a license. That is possible. So nobody is forcing the patentee to give a license, but they are under an obligation in law to give license to everyone.
Okay, okay. And ma'am, these you said it has to be on fair terms, right? So now, when he's giving out license, the term fair terms can be is a very wide term. So is it restricted by some law or by some precedents, or who decides these terms? Whether what kind of terms will be there while giving out the license by the patentee?
Yeah. So, fair and reasonable terms means these are terms which are agreed upon between the parties. Normally, there's a lot of jurisprudence now which has
Hmm.
developed over the last few years as to what these fair and reasonable terms can be. One is, of course, of
Hmm.
royalty, and one is of the technology to be used. So,
Hmm.
royalty, there is a lot of controversy on how much the royalty can be. There are a
Hmm.
lot of people who who believe that the I mean the patent owners believe
Hmm.
that the royalty should be in the range. It can't be the same for everyone,
Hmm.
because there may be some handset manufacturer who is like a Samsung,
Hmm.
and there may be some other handset manufacturer, perhaps in India or elsewhere, who is a newcomer in the field. So if you ask for 3% royalty, for example, from Samsung, and
Hmm.
you're going to ask this man also to pay 3% royalty, and his phone is
Hmm.
priced only at rupees 2000, if he is going to pay 3% royalty, it will become a difficult option. It will become very difficult for him to sell the product in the market. On the other hand, Samsung may not have a problem with 3%. So therefore, the term has to be reasonable as per the party, as per the patents that he is asking for. So he may suppose somebody says, I want to implement only 3G and 4G and I don't want 5G. 5G
Hmm.
has not yet come in, but then I'm just
Hmm.
saying as an example.
Hmm.
In case someone says, I want to implement only 3G in my phone, I don't want 4G. So there will be
Hmm.
only four patents to be licensed. If only four patents are to be licensed, and I'm going to sell only in India, I'm not going to sell all over the world, then the amount of royalty that I should pay will also come down. So it's a matter of negotiation. So it can't be defined. There can't be a specific definition, or there can't be specific format of those terms. But yes, royalty is one
Hmm.
of the important terms. Giving out the technology is a very important term, and these are
Hmm.
all things which are to be decided between the parties.
Okay. There's a question. We'll just take it because it's related, and then we'll move on, ma'am. The question is there any community guidelines that is also given? For example, if for a particular industry, probably as a matter of practice, there's some guidelines have come. Is such a thing there around this negotiation?
Yeah, there are guidelines which, if you see, there are so many cases now which
Hmm.
have developed. There are cases in Europe, there are cases in US, there are cases in India
Hmm.
also. So there are some guidelines. There are some guidelines that we can think of around which
Hmm.
the terms can be negotiated. So the patentee, normally what happens is the patentee comes up and he says that, look, I've got 10. These are the 4, 5, 7, 10 patents, and this is the rate I am offering,
Hmm.
and he gives you a range. Then it is for you to study those patents,
Hmm.
and then you go back to him and give him a counter offer. He may accept that offer, he may not accept the offer. Then it's like a ping pong which negotiation which keeps going on between the
Hmm.
parties, and then you decide whether to take it or not to take it.
There's just one another follow-up question. You said that generally it's obligated upon the patentee to give out licenses. Are there any grounds on which he can actually withhold them for any reasons, or it has to give them out?
He has to give them. He has to give it on license. It is not possible for him to say, I will not give. Then it becomes antitrust, or it becomes anti-competitive. Then straight away a person will go to
Hmm.
the competition commission and say that, look, this fellow has got 10 patents, all for the 4G.
Hmm.
It is part of the
Hmm.
standard, and this fellow is not licensing it out. It will become straight away
Hmm.
a case of abusing of dominant position. So therefore, no one will ever, no patentee who is a holder of SEP technologies will ever do that. But what they do is something else. they have
Hmm.
different grades of patents. They have those
Hmm.
patents which are fundamental, essential to the technology. Then they have those which are less essential. Then there are
Hmm.
those which are entirely unconnected, but which are somehow
Hmm.
related, peripheral patents. Their aim
Hmm.
is to have all these patents within the SCP and within the standards. So it is for you as a licensee to find out which are the patents which are essential, which are not essential, and tell them that look, out of your 15 patents, only three are essential.
Hmm.
I'm going to pay you royalty for those three.
Hmm.
And the royalty that I will
Right.
pay is this much. Why? Because
Hmm.
the amount of phones that I'm going to sell in the market is only going to be in perhaps India. I'm not going to sell outside of India. My market is so and so, my size is so and so, the production is so and so, my manufacturing cost is so and therefore I can only afford to pay you perhaps 1% royalty or 0.5% royalty or whatever. I can't pay you beyond that. So this is an offer that you give, and then he gives you a counter offer. So he cannot hold back and say, I will not give you license. That becomes an abuse of dominant position.
Hmm. Okay. So moving on to the next question, ma'am. What does the manufacturer do when he receives a FRAND notice?
So the first thing when he receives a FRAND notice is to first,
Hmm.
study all the patents. Normally, when you get these kind of notices from the patenting, you will get a
Hmm.
notice saying that look, I've got 15 patents, and you must take a
Hmm.
license for all those 15 patents because they're all essential for as a standard essential patent, and they cover the entire technology.
Hmm.
Then it is for you to employ
Hmm.
a bundle of bunch of people and then just study those patents in and out and find out whether they
Hmm.
are really essential or not. If they are
Hmm.
essential, then they will be registered with the standard setting organization. You can visit the website of the
Hmm.
standard setting organization and you can find out the portfolio of patents which are actually listed there. So
Hmm.
it's not a black box that you can't see. You can actually visit the
Hmm.
website and you can find out which are the patents which are actually listed there and which are essential. And then you can say that look,
Hmm.
you are asking me to take a license of 20 patents, only
Hmm.
5 of them are listed. Out of those
Hmm.
5, perhaps 3 of them have lapsed. I'm going to pay you
Hmm.
royalty for 2 of them. Then it is for him
Hmm.
to come and justify that sorry, even if 20 are listed, I want royalty for all the 20 for the following reasons. So it's up to
Hmm.
him to sort of come back to you on that. But it is for you to essentially take precautions and study this whole thing in detail. What I have seen a number of times is either people don't respond,
Hmm.
or if they don't respond, the response is not adequate enough, in the
Hmm.
sense that you must go back to them. If they come and tell you that I will give you I will give you royalty, you have to pay me royalty of about 4%. You have to go
Hmm.
back to him and say that no, 4% is not justified. I will only pay you 1%, and please tell me how much royalty you have offered to the other people. Who are the other people whom you have granted the license? What is the royalty that they are paying? You are
Hmm.
entitled to know all these facts. So, in fact, you have to start off on a discovery mission to ask all the relevant questions, find out about those patents, and then distill out those patents which are actually essential to the standard, and then perhaps decide whether or not to pay the license for those standards.
Hmm. Okay, ma'am. So you also said that you can ask for information as to what all people or what all companies have license and what royalty they are paying. But is there any way that information can also be covered under the privity of contract, and whether they can deny such information of the amount of royalty they are receiving from other people?
It's a very good question. People do deny. You can then there is a way out of that. You can say that we can have a confidentiality, agreement between
Hmm.
ourselves, and
Hmm.
at least if they cannot, if for example, if Qualcomm has given the license, say to
Hmm.
Apple, at a
Hmm.
particular range, they
Hmm.
may or may not disclose the exact term to you, but they can give you the range and in a
Right. Right.
verifiable manner. So they can tell you that,
Hmm.
yeah, it was between 1 and 2%. And you
Hmm.
can perhaps, they can give you documentation so that you can verify it. So you can sign an NDA with them, and based on the NDA, with with the confidentiality in place, you can exchange information about yourself. You can call for information about the licenses that they have granted. So that is a very useful thing to do. But it is essential for us to know what is the license fee that they have granted, what is the license rate that they have granted elsewhere for other countries and for other licensees, so that you can determine whether I must pay
Hmm.
that same amount or I should pay more or I should pay less.
Right. Does courts also play some role in these kinds of negotiations, ma'am?
Yes, sometimes
If
what happens is,
somebody is holding, hmm.
yes,
Yeah,
yes.
yeah, please go ahead, ma'am.
Yeah, sometimes it does happen that, you have given certain offers and counter offers to the patentee, and the patentee for some reason is either
Hmm.
delaying the matter, or he has not offered you terms which you think are not reasonable. Then it is always
Hmm.
open for you to go to the court and ask so that the patentee is obligated to grant
Hmm.
the license to you on reasonable terms. So the court can
Hmm.
play the role of a mediator. Maybe, you can even ask for the appointment of a mediator.
Okay. Okay. Now, ma'am, now all of this is in case where negotiations have happened or even license has been granted. What in case if somebody is using somebody's patented technology and now on what grounds infringement suits can be filed by a patentee?
See, a patent holder is only supposed to offer you the patents for a license. It has to be a willing licensor and
Hmm.
a willing licensee. And if you are not willing to take the
Hmm.
license, then
Hmm.
this obligation is over. You can't shake
Hmm.
hands only with yourself, right? You have to shake hands with the other person, and the other person must extend his hand for that. So if he is not willing to take the
Hmm.
license, or if he is unnecessarily
Hmm.
delaying it, or there is some other
Hmm.
issue out there, then of course it becomes a
Hmm.
straight case of patent infringement, that you are using the standard, but you're not willing to pay for it.
Hmm.
So it becomes a
Hmm.
case of patent infringement, and then the patentee, approaches the court. At that time, you can't go back.
Hmm.
You will be going back to the court and saying that, look, at the end of the day, I'm supposed to pay royalty to him. He's not taking my
Hmm.
royalty. He's not taking the royalty.
Hmm.
He is not engaging in a proper discussion with me. Again, you
Hmm.
come back to the same thing, because ultimately, in these
Hmm.
kind of technologies, the only solution at the end of the day is royalties. So when you
Hmm.
if you are unwilling, and once you go to the
Hmm.
court, then you express your
Hmm.
willingness, then you're setting the clock
Hmm.
back to the day one
Hmm.
when the license was offered
Hmm.
to you. When the license was offered to
Hmm.
you, you refused it. You have an
Hmm.
incalcitrant attitude. You stand back and you say, no, 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 I don't want to take the license. When they go to the court, then
Hmm.
it's a suit for infringement. It proceeds in that way.
Hmm.
This is how the suits for
Hmm.
infringement come up.
Hmm. Okay. Okay. Ma'am, the next question that I would like to ask you is how has the law around this evolved in India? And are we at a better position now? And what are more things that should be, probably included by the courts in the act itself, or probably by the court's intervention? Like, what is the way ahead from here? What are the lacunas that can be worked around the jurisprudence of patents?
There's a lot of jurisprudence that needs to evolve here, because
Hmm.
the cases that we have seen so far are those
Hmm.
cases where one party or for example, we've had the Ericsson engineered Ericsson cases where Ericsson has filed a
Hmm.
number of cases against other manufacturers,
Hmm.
handset and chipset manufacturers. So Ericsson, initially, for example, in that Micromax case, they sent a notice for the 2G, 3G, and the 4G technologies. There was no compliance because Micromax didn't come back to them with a proper reply and all, and ultimately it ended up in the court of law where
mm,
Micromax was asked to pay certain royalties at the end of the day.
mm,
And Micromax also went to the CCI for abuse of dominant position, and that investigation is still going on.
mm,
Similarly, in the Xiaomi case also, they were injuncted. Ultimately, Xiaomi came back and they said that no, 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 we are using the chipsets from Qualcomm, and then they were allowed to sell those chipsets which were actually licensed from Qualcomm. So there's a lot of jurisprudence that yet needs to evolve in this, because there's a lot that can be done here. Here we have to evolve things as per our own standards. You see, in India, we are not like the West. We are not like Europe or US, where we are entirely advanced,
mm,
where the handset manufacturers or the chipset manufacturers are very advanced and they are equally well versed with all the patents.
mm,
In my experience, I've seen that perhaps the Indian companies need to do a lot. They need to do a lot of patent studying. They need to spend a lot of time studying those patents and working around them. Perhaps have their own workaround around it.
mm,
So if there is a particular technology, and let's say 10 patents are listed on the standard, you can achieve the same standard. You have to follow the standard, but then
mm,
you can develop your own mini technologies around it. So
mm.
if you do those kind of things, then perhaps you will be able to. Perhaps you may then tell Ericsson or other companies who hold the patents that look, yes, we are using the standard, but we have got around your patent by using a different technique, and we are very well capable of doing that. So that one, on technology we need to develop, and second we need to develop, we need to have this whole thing about reading the patents properly, understanding them, and then finding out what are the loopholes in those patents or how we can get around those patents, or we can, if those patents are indeed so valuable, then how we can value them and pay appropriate royalty. Yeah, Srishti, you're back now.
Yeah, yeah. I think there was some issue in the internet, I think.
Yeah,
Uh,
yeah, correct.
yeah, okay, ma'am. Okay. Then another question that I want to ask you is, how do somebody files an infringement suit where the patentee is not an Indian citizen, the technology and the patent granted is in a foreign country, and but it has been infringed in an Indian jurisdiction. So whether such party has a stronghold given the Indian judicial system and the act here, and how can he proceed here in an Indian country?
Of course, every company can come and file a suit here as long as they have the patents here, and if those patents are being used by the Indian companies, then certainly they can file a suit here in India. There is no doubt about that. It often happens even in respect of trademarks. You have
Hmm.
Alpenlevy trademark, for
Hmm.
example. If someone is using Alpenlevy here,
Hmm.
of course, the foreign company can come and file a suit. There is no doubt on that.
Okay. The another question that I want to ask is when parties negotiate for license fee and everything and royalty, have you seen that there is a change with respect to keeping the litigation to Indian courts, or people have moved a lot to arbitration or ADR methods? Has that happened?
No, they have not gone to ADR, but what has happened is that people that has become multi-jurisdictional.
Hmm.
So if the other company, if normally if the company is from India only, then they
Hmm.
will keep the litigation to India because Indian companies will not go and litigate outside of India because it's
Hmm.
very expensive. On
Right.
the other hand, if you have companies such as Xiaomi or someone who has a
Hmm.
base elsewhere in China, perhaps,
Hmm.
so those companies tend to initiate litigations outside India also. So
Okay.
they may file a suit for declaration outside India, and
Hmm.
then there may be parallel litigation in India.
Hmm.
So if there are 10 patents, then Xiaomi may file a suit in China for certain patents,
Hmm.
declaring that those patents are not essential to the standard, whatever. And in India, Ericsson or other companies may file the suit here. So we have seen that kind of thing happening, but we have
Hmm.
not seen people going to ADR and other mechanisms. Of course, the court can always refer the parties to mediation.
Okay. 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 And ma'am, can you discuss some few judicial precedents which are essential to the jurisprudence that has developed around the law?
Yeah, so there are some cases that have really, set the standards. Though in India we have not come across any case where, the actual standards have been set. I would have really loved if there are some cases which actually discuss the jurisprudence on what should be the royalty
Hmm.
and under what circumstances the royalty should be paid and
Hmm.
how much royalty should be paid. All
Hmm.
those things, if they had been discussed in Indian jurisprudence, it would have been really nice.
Hmm.
Because the essential thing that needs to be now decided is if your patent is covering only one particular portion of the chipset
Hmm.
and performing only one function, why should
Hmm.
I pay royalty on my phone? I should only pay royalty on that chipset and for that function which it is performing.
Hmm.
Instead of paying 100 rupees on that phone,
Hmm.
the amount of royalty that I should pay is only the role of that chipset. If it is only 4G and it is only performing a certain function, then I must only pay only for that. Why should I pay the royalty for the entire value of the phone?
Hmm. Right.
You see, the
Right.
value of the phone may be 12,000, but the
Right.
chipset may cost, say, 3,000.
Hmm.
So I should pay royalty on that.
Hmm.
So that kind of jurisprudence is yet to come up in India. We haven't gone to that extent. We've had many cases like Ericsson versus Micromax or Ericsson versus Xiaomi, and we have
Hmm.
now interdigital cases which are going on, all on injunctions,
Hmm. Hmm.
where we have seen that as an interim measure, the court
Hmm.
is granting injunctions and
Hmm.
the parties are asked to pay certain royalties. Same thing happened in the Lava case also in Ericsson versus Lava. But
Hmm.
these cases are causing a sort of a paralysis in the Indian industry because with the excessive amount of royalty, the
Hmm.
Indian companies aren't able to match up. So the
Hmm.
Indian companies will have to do some introspection in terms of studying the patents, in terms of setting up their own standards, in terms of
Hmm.
developing their own technologies and working around it. So there's a lot of scope where they need to do a lot of homework.
Mm, right, right. So, ma'am, you said that the jurisprudence lacks in terms of, probably setting standards around royalty and on what component the royalty can be paid. Is it because these kind of legal premises have not been adjudicating before the court, or is it that courts have not decided to infringe in this domain yet?
No, it is not that courts don't wish to enter into the domain. Courts will always
Hmm.
adjudicate any issue that is brought before the court. But
Hmm.
such issues have not been argued at length before the court. This
Hmm.
issue by itself has not been placed before the court. So no one has, if for example in those cases of Huawei versus ZTE or
Hmm.
Qualcomm and Apple, which are going on outside India, in those cases, the legal framework for the SEP litigation has been decided, and some of those things are being applied here. Some of that jurisprudence is being applied here. But in India, we have focused the patentee and the defendants have both
Hmm.
tried. The defendant has tried to avoid the injunction, and the patentee has
Hmm.
tried to enforce his injunctions. So that's where our focus
Hmm.
has been. However, our
Hmm.
focus should also be, of course, apart from the injunction, also on the
Hmm.
issues as to royalty. But then none of those
Hmm.
cases have actually reached a final stage. So really, we can't say much. So it may be possible that when the case goes to the finality, when it is finally decided, some of these issues may get
Hmm.
adjudicated.
Hmm. Just a follow-up question now that we're discussing injunctive suits and how courts are granting injunctions and also asking party to pay the royalty to a certain extent. So in most of the cases, have court decided in the favor? I mean, what kind of approach the courts take in granting injunction in such matters? Are they proactive in granting them, or what kind of grounds they see?
So court looks at the conduct of the parties. Conduct is the most
Hmm.
critical thing. If it is
Hmm.
shown that the conduct was that, look, I sent them a notice, and after that
Hmm.
the manufacturer, handset manufacturer, has not come back, has not
Hmm.
negotiated with me, has not discussed with
Hmm.
me, then the court takes it
Hmm.
otherwise. Then the court says, why did you not negotiate? You should have
Hmm.
negotiated, and you are
Right.
continuing to use the standard, so you must be
Hmm.
injuncted. The court is right on that. That's how the
Hmm.
injunction comes. On the other hand, if you had actively negotiated with them, given
Hmm.
them counter proposals,
Hmm.
and torn apart their patents,
Hmm.
perhaps they may also wish to discuss with you about the offer of license. So those are the aggressive stands that we need to take going forward. And instead of
Hmm.
saying that, look, okay, there are 15 patents, I'm not going to license them, I'm going to only do four, and what are your
Hmm.
rates? Tell me all the rates. You have to
Hmm.
go beyond that. We have to take a
Right.
more
Right.
aggressive stand and a more detail oriented stand.
Hmm. Hmm. So the ma'am, just a follow-up question on this. Now that you say that there are a lot of cases where infringement has taken place or probably negotiations failed. So parties, companies are trying to use the patent without a license is because there is high royalty that has to be paid. Is that one reason because the law lacks? What is the reason that people actually dwell into such practices, knowing that ultimately it may backfire them if the company finds or the patentee finds out whenever that the patent is being used?
I think all the manufacturers know by now that at the end of the day they will need to pay a license.
Hmm.
But I guess it is, you know, I think it is the way the businesses operate in India that, well, we will start off and then we will decide as we go along.
Right, right,
But
ma'am,
I
right.
think we need to move from there and we need to go into a more studied approach where you need to
Hmm.
study the paths much in detail before you embark on that. So it
Hmm.
is not
Right.
because they are not aware. I am quite sure that most of them by now are aware that they do need to pay
Hmm.
royalty if they are going to be
Hmm.
using a certain technology. They are aware,
It is
but
only for the time that
yeah,
they
I'm
think
not
it's
talking
better
about
to
it,
exploit
trying
it
to
till the
buy.
time they can.
Yeah, trying to buy time basically is one of the approaches which we have seen very frequently. But I think they need to
Hmm.
do something better. They need to invest on technology. They need to invest on patent studying, patent portfolio management. These are things that we need to think about and
Hmm.
invest on.
Right, right. Just a follow-up question on this also, ma'am. Do you think people or companies or probably lawyers or anybody just doesn't want to dwell into this or do a thorough research because it is more technical compared to other things like trademark and copyright? Is that one reason, or there are some other reasons that the law people do not do their thorough research or do not want to, have a well-researched approach
No,
towards
I
it?
think it is not because it is complicated. It is only because
Hmm.
uh, I think it might be because they need to spend just time. They haven't got down to getting there to do that. I don't think it is because it is complicated. Of course, it is more complicated than trademarks, and obviously, it is definitely more complicated than copyright. It is a known thing. It is very complicated as compared to other technologies. It is certainly very complicated. But there are experts
Hmm.
available around the world, and experts
Hmm.
even available in India. You have a lot of
Hmm.
IIT professors and a whole bunch of people who keep reading
Hmm.
these patents day in and day out as part of their livelihood. And
Hmm.
I think it is time now that we need to get to that kind of a space where we need to get into that kind of a time that we need to get a more researched and better approach so that we
Hmm.
get benefits out of it. We learn from
Hmm.
the jurisprudence that has evolved in other countries, the
Hmm.
European countries, the US, and other places.
Hmm.
Or learn from Chinese companies like Xiaomi, who have invested a lot in technologies. So I
Hmm.
would, it would be nice to see the day when Indian companies are making that kind of investment and
Hmm.
investing into that research, also doing so much of study into the patents. That's when
Hmm.
you get the actual benefit out of it.
Right, right, right. Ma'am, that was very enriching session. Something that you would like to add probably towards the end of discussions, because I don't think so. We have a lot of questions today. Nisha has a question. If you can repeat the case laws once again, ma'am, the landmark cases that we discussed towards the end.
So there are some cases in India. We have the Ericsson cases, Ericsson versus Micromax,
Mm,
Ericsson versus Lava, Ericsson versus Xiaomi. These are all the cases in India. Then you also have the
mm,
interdigital cases, interdigital versus various parties, and these are Dolby also. The Dolby versus so many parties. Those cases have been there in India. In outside of India, you had the Huawei versus ZTE and TCL versus Ericsson. So that was one of the cases where TCL went to the court saying that, look, Ericsson is not offering me license on frank terms. So those are the kind of cases that we should see here in India. And then you had, of course, Apple versus Samsung. Those are some of the important cases in this field.
I dropped out due to some internet connection.
Yeah, I know. I can understand.
Yes, yes. Sir. Thank you so much, ma'am, for joining in today. Okay, there's another question. We'll just take few questions, ma'am. The question is from Praveen Kumar. He says, "Can you please suggest how to learn basics of patent litigations?"
So the basic, I think you must read some judgments, and you perhaps interact with people who are doing patent litigation. That is how you will learn about it.
Yeah. Are there some points that probably somebody can start in college, or somebody who is just into profession can focus on to learn patent litigations? Or
Yeah,
there's
I
some
think you
course
must
probably
read
they
up.
can take?
Yeah, they need to read up the Patent Act, and they need to read up some of the cases, the jurisprudence that has evolved so far, and then watch some of the cases that are going on, and that is how you will learn about the patent cases.
Right, right. Uh, I think that's all for the questions today. Anybody who has a question can ask in before we take a leave from the expert. I think that is all, ma'am. That was a wonderful session, ma'am. I got to learn a lot about. Okay, there's another question. Can patents company change royalties or tease that company about changing royalties when he got that he's going more sale than expected? Company who took patent certification. Okay. The question is probably we the company agreed on a certain license fee, and then probably the sales shooted up for the company. So can the royalties change knowing that they are making exorbitant profit on the sales now? Can the initial terms be
Yeah.
renegotiated based on
So
the profits?
no, so what happens is the royalty is fixed on the royalties are fixed in different ways. There is something called a sliding royalty, and there is another way of fixing the royalty depending upon your sale. So if this year your sale, if this quarter your sale is say 2 lakh units, so you will pay royalty only on 2 lakh units. Next quarter,
Hmm.
if your sale is only 1 lakh units, you will pay only on 1 lakh units. And
Hmm.
in 1 year, perhaps you will pay, the rate will be say 0.1%. The next year, your rate will perhaps go down or higher. So these are all points of negotiation.
Right, right. Uh, I think that's all right. No more questions I see from anybody else. So, ma'am, thank you so much for joining in. Thank you so much for giving your time. We learned a lot of practical aspects about the jurisprudence and how the law is going to develop and what are the lacunas that are still there in the Indian law. Thank you so much, ma'am. And thank you so much for your time. Probably we'll also join again once to discuss more aspects of it.
Sure. Thank you so much. It was a great pleasure. Great pleasure.
Thank you, ma'am. Have a nice day, ma'am. Thank you.